Nnamdi Kanu sacks legal team and chooses to defend himself. Is this a masterstroke or last straw of the dice? In a twist that has shocked both supporters and critics alike, the detained leader of the indigenous people of Biafra, IPOB, as Mazi Nnamdi Kanu, has reportedly withdrawn the services of his legal team and elected to defend himself in court. It's a dramatic shift that has left the political and legal landscape buzzing with uncertainty and curiosity. How does he intend to go about that? Listen to one of his legal representatives here, and I'll be right back.
Thank you very much, and good day to all lovers of freedom. My name is Nnamdi Kanu. I am one of the lawyers to Nnamdi Kanu. Today being the 23rd of October 2025, Nnamdi Kanu opted to defend himself in open court. Processes had been filed and motions had been moved. So he filed motion challenging the jurisdiction of the court. And after the motion was moved by himself, according to what we heard, because when he asked that he would defend himself, the judge directed or ordered that all his lawyers who had appeared with him or for him before now should leave the courtroom. So we all left, except the senior advocates of Nigeria, who my lord ordered to sit back, and they sat back. So, but we left as directed by court, and Mazi Nnamdi Kanu, as we later heard, moved the motion, which he filed by himself, challenging the jurisdiction of the court. I understand that the court insisted that he has jurisdiction and continued to hear the matter. We also were informed that he raised the issue of his medical certificate of fitness issued by the Nigerian Medical Association. And he drew the attention of the court to the fact that the Nigerian Medical Association issued a certificate of fitness on the 23rd of September 2025, whereas the court made an order for the Nigerian Medical Association to do that report on the 26th. So we noticed that the medical report came long before the order of court was made. And Mazi Nnamdi Kanu's position is that that medical report is not the one ordered by the court, and that the medical report is corrupted. But because on the last date before today, when we appeared in court and that medical report was tendered, the lawyers, we didn't object to that medical report. Possibly it's an oversight, I think. And so my lord said that since he had ruled on that medical report, he is found official, he can no longer go back to that medical report, and ordered him to go ahead to present his defense. We understand also that Dr. Nyeti Bazo stood up and intervened as a friend of court and requested my lord to grant Mazi some time to reflect and maybe constitute another team of lawyers that will lead his defense team. So be that as it may, the case is still on. It's adjourned to tomorrow, 24th October 2025. Hopefully we'll be around. If the court permits us to come inside, we'll come inside, but if not, then we'll just hang around and try to get information as to what transpired. So as of today, Nnamdi Kanu has briefed us as his lawyers for this particular case, not for all cases, but for this particular case. So hopefully by tomorrow, he might have to reconstitute another team. Thank you very much.
All right. Thank you very much.
Thank you.
Sir, yeah. My name is Prince Elias Odemena. I am the convener of the Igbo Union in the country Igbo. Please, I want to debunk the stories going around the town because of the protest show a Yoruba man called. They say that the Igbos abandoned Nnamdi Kanu. That is a false statement. We, the Igbos, we are 100% behind our brother, Mazi Nnamdi Kanu. Thank you.
All right. Thank you.
Okay,
All right. Thank you.
For a man who has spent over 3 years in DSS custody, exhausted countless adjournments, survived courtroom theatrics, and endured medical neglect according to his team, such a decision does not come casually. It is a gamble wrapped in frustration, strategy, or both. But why did he sack the lawyers? I'm just curious. The final straw, observers believe, came from what Kanu considers divided loyalty and misplaced priorities. Instead of focusing relentlessly on research, motions, and a tight legal strategy ahead of the next hearing, members of his legal team were seen leading and participating in street protests, providing optics but not results. That cannot take him anywhere. This is a testament that what some of us see is nothing but the way forward. I've said this several times, and my picture is even in my video. Did you watch my video where I spoke about the participation of his lawyers in the protest? I analyzed details on this. Some people thought I was being unfair to the lawyers because they felt that they had the right to participate. How can a serious-minded person abandon his house on fire to chase rats? Or is there something they are not telling us about this case? Kanu has probably seen through their antics that they are not confident in winning the case. Hence, they have resorted to drawing public sympathy rather than facing their own task. Supporters applauded the protests as pressure tactics. Kanu, however, seemed to interpret them differently. I can hear Kanu saying, "You cannot protest my liberty on the road while abandoning the battleground where liberty is decided," which is the courtroom, of course. Whatever action, whatever power or strength is devoted there is supposed to have been in the courtroom because that is where they belong. The symbolism is clear. The symbol is clear. No intellectual. The symbolism is clear. He expected intellectual warfare, not emotional theater. Khan is a wise guy. To him, the lawyers were chasing cameras, not justice. You can't get justice on the street. Watch almost all my videos, you see what I've been saying. Let us consider his decision to defend himself. Is it confidence or desperation? What do you think could drive him to this? Self-representation is not unheard of in history anyway. Mandela once did it. So did Gani Fayemi. But the courtroom is not a stage for sentiments. That is what I have to draw out now, what I have to drum. It is a battlefield of technicality, especially as it concerns Nigerian situation. Status, procedures, and precedents. Kanu's chances depend on three key factors. And these are factors that can either make or that can help or maybe harm him. He needs to decide clearly. He needs to be careful with every decision taken concerning it. The first thing is to consider his mastery of his own case. He knows the root of his detention better than anyone else. So he could leverage on that. Then another thing is procedural complexity. Nigerian terrorism laws are strict. A legal mistake could backfire. That is what he needs to put at the back of his mind. Public perception versus courtroom reality. Kanu needs to realize that sympathy outside cannot overturn a ruling inside the court. Whatever mistake you make there is final. Let us watch some of his recent presentations in courtroom. What he has done for himself since taking over the case. I think we'll have a video about that.
But that's what you wrote. You said here, my lord, that the defendant has now applied for bail. Now, as I said earlier, bail is a discretion of the court, taking into consideration all the conditions laid down in Muhammad Abacha v. State. At this stage, I am of the opinion that to make or take a stand on the bail application without first hearing and determining the issue that is glaring in the face, which is the absence of the defendant from the court since 25th of April 2017 until he was produced on the 29th of June. My lord, which was exactly what the Supreme Court did. They said that he did not jump bail. These criminals came to my house to kill me. That's what the Supreme Court said. your own court, my lord. So I cannot understand, my lord, why my trial will be conducted contrary to the Constitution of Nigeria that said I must have free and unfettered access to my counsel. Is here. This is the law of Nigeria.
Now the question is that is begging for answers is this: is he betting on law or on public pressure? What is he actually betting on? Some analysts suggest this bold move is a deliberate political statement that is shifting the narrative from lawyers fighting for him to a man confronting the system personally. By standing alone in court, he essentially frames it as Kanu versus the Nigerian state rather than Kanu versus the prosecution, as was done by his former legal representative. It also raises curiosity. What does he know that other outsiders don't? What does he know about this case? Does he have a legal bombshell prepared that is going to shock everybody? Or is this the last attempt to force political negotiation rather than judicial outcome? What does it actually seek to achieve from this? All eyes are now on the coming court sessions. Will this decision reawaken the case or cripple it? We wait to see that. Will standing alone make him appear stronger or legally vulnerable? We need to put all the stake. Did he outgrow his legal team or abandon his shield in frustration? Were they all along protecting him? Whatever the answer, one thing is certain. The next court sitting may be the most closely watched moment in his entire trial, because for the first time, Nnamdi Kanu will not be represented by any legal team. He will be unfiltered. He will present himself. And that alone has already changed the game. Kanu has asked for more time to enable him access or retrieve his case file from his former lawyers and to constitute another legal team. I will conclude by reaffirming my continued suggestion that the political and traditional rulers of Southeast region be sufficiently consulted on their stake in this case. What is their stake? What do they want? What is it they know or they are trying to prevent that we do not do? Not all leaders will accept a level of insecurity in some parts of the country and so will stop at nothing to curb any such semblance of terror by non-state actors in their region. Probably that is what governors are trying to say. Please share, subscribe for more authentic and unbiased analysis to Newsrip. Thank you.